in the fellowship of the judiciary, a fellowship that I have missed for about the last 3 years, having retired due to effluxion of time in 2007. The Sharp case brings back a lot of memories, and it's most interesting to me, at least, that I've been invited here to be a participant in a conference that has as its main aim sentencing. I think we're spilling a little beyond sentencing at the moment, but we are in the area of the effect of the media upon what we do. And as many of you may know, what I had to do was, under the glare of the media and under the glare of immense outpouring of disapproval of what I did. I'll mention in parenthesis that there was some approval, but not much. And I'll also mention as well that while this firestorm was burning, an immense number of judges from across Canada wrote me notes and basically saying, hang in there, whether we agree or don't agree with your decision, hang in there, you're doing your job. And I will say that the receipt of notes of that nature gave me great sustenance, and I thank everyone who went out of their way to do that. I noted I didn't get any from the members of the BC Court of Appeal, but they are. But I'll say this in their defense.
I wasn't on the Court of Appeal.
No. I'll say this in their defense. None of them, until the actual appeal took place, knew whether they would be sitting on the panel that sat in appeal from my ruling. Now, to go back and give you a little detail, Mr. Sharp was charged with 4 counts of possession of child pornography. 2 charges were of simple possession, that is, possession that doesn't have any purpose connected to it, just simple possession. 2 of the charges were of possession for the purpose of sale or distribution. And that distinction was extremely important in what I had to decide. Mr. Sharp came to court without counsel and ran his side of the case throughout without counsel. He announced at the beginning that there was a constitutional challenge. It didn't look particularly like a serious one at the start, but as the case wore on, it became very serious. I was put in a rather difficult position because Mr. Sharp was not a lawyer and did not have the skills that a person putting forth a position that he was ought to have. So and I will say this, that Crown Counsel, who is now on the BC Supreme Court bench, Terry Schultes, was extremely helpful to the court from one end to the other and extremely fair. Indeed, when he was appointed, I wrote him a note and said, "Dear Terry," and pointed out that I thought he was a good appointment because he had that gift of fairness in him, which is useful in what we do. Now, he carried on this attack, called some witnesses. The Crown called many witnesses to support the underpinnings for the simple possession of child pornography. Basically, cross-examination was up to me because Sharp could not do it properly, so I did it. And finally, argument and decision. I will say it was the toughest decision I ever had to make in 20 years on the bench. The main reason it was tough is that it was purely and simply a difficult question of law that I had to face. It was one on which there was very little guidance in the case law, and on which there were arguments and counter-arguments and counter-arguments in practically every which direction. This came out in the appeal process, where the Court of Appeal came down with 3 separate reasons for judgment: 2 upholding my decision that the simple possession provision was unconstitutional, 1 to the contrary. The Supreme Court of Canada in due course reversed the Court of Appeal and reversed me. But even then, the 6 majority judges decided there were unconstitutional aspects to the provision, but they were not such that could not be overcome by interpretation, which they did. The other 3 judges in the Supreme Court of Canada held that the simple possession provision was constitutional, period. You read these sets of reasons for judgment, and every single one of them reflects an immense amount of work by the judges who wrote those decisions, and they are going in every which direction conceivable. Well, that comes with the Charter. The Charter can be tough at times, and it was in this case. So the decision was handed down, and the outpouring of media and public disapprobation exceeded in volume and fury anything I've ever seen in Canada for a court decision. It was a field day for television and the newspapers. A majority in Parliament was ready to use the notwithstanding clause of the Charter to uphold the criminal code and overcome my decision. Fortunately, wiser counsel prevailed, and the Crown decided to go the appeal route. Most reactions were not only dead against the decision, but dead against the judge who wrote it. A few commentators supported the decision, and several leading members of the bar rose to my defense, and I bless them. The police protected our home. The furor was probably harder on my wife than on me, but was an unpleasant experience for both of us. Complaints were filed with the Judicial Council, and the last count I heard, there were 50 of them, and many of those had petitions annexed to them where there were hundreds of names supporting each one. Judicial Council made short work of the complaints. Jeff Oliphant was the person on Judicial Council who had the duty to oversee complaints in respect to British Columbia. Al McEachern here was doing it for the rest of Canada. Jeff had the wisdom to answer each complaint, basically saying, this is a judge doing his job, and by the way, please read the decision. Here is a copy of his reasons for judgment. I thought that was a good reaction by him. Of far-reaching effect was a hotline show in British Columbia. The hotliner, who was actually visiting BC at the time, carried on day after day. I never listened to him, but I was told by friends who did that the constant reference was to Mr. Justice Bonehead. Well, he may have been close to the mark, but one of his staff telephoned my home and spoke to my wife. I had already left for work, and asked if I would appear on the show to explain the judgment. And my wife replied, well, I don't think he would be prepared to do that, but you should call him directly and ask him. Well, they didn't call. And the next day, the hotliner said that Mr. Justice Bonehead is now hiding behind his wife's skirts. Anyhow, off it went to the Court of Appeal and on to the Supreme Court of Canada. And the Supreme Court of Canada rendered its decision. I was faced with the question of whether to continue to be the trial judge. This is just a ruling during the course of the trial. I won't go into the question as to how it could proceed through the courts with the trial not being over, but be that as it may, I was still the trial judge. I had to ask myself, will you continue to be the trial judge? Particularly after this outpouring of disapprobation. And the conclusion I came to was it's going to get hot out there at times when you're a judge, and you better withstand the heat and carry on. And so in final analysis, having contemplated whether I should continue, I decided, yes, I should continue, and did. The Supreme Court of Canada gave a considerable amount of advice, I'll call it, guidance, I guess is a better word, about the interpretation of the child pornography sections. The evidence was called as to whether or not there was artistic merit. I concluded there was artistic merit. That didn't mean to say I thought it was good merit. It wasn't. But that there was some, and that's all there had to be, some. Another issue was whether there was counseling the commission of child sex crimes. I concluded, no, this glorifies an area that is very much against our instincts, but it wasn't counseling. And those were the two basic defenses to the written child pornography aspect. Therefore, I acquitted on that point. As far as the photographs, there were photographs as well. It was really no contest. After what the Supreme Court of Canada had ruled, there had to be a guilty finding, and indeed defense didn't do much in the way of defending on that aspect of the charges. The final thing was sentencing. It was very clear from the public outpouring, the media outpouring, that this man landed on a sensitive nerve. He was viewed as a sexual predator. He wasn't charged as a sexual predator, but he was viewed as a sexual predator. He had gone public after the initial constitutional decision. This helped whip up the firestorm. Obviously, the general public would have been quite happy if I had sentenced him to every bit of time that I possibly could and thrown away the key. But that's not our job, as you know. And I took into account various factors. He, by this time, his late 60s, very ill. He had been under bail conditions that were strict for 6 years. He was not charged with with being a sexual predator. There was no record of that nature at all. And and he had been in effect thrown out of his home, which was an apartment building in Vancouver, by being hounded out by people around him. When I put that all together, I decided that 4 months of conditional sentence and various conditions was appropriate, and that's the sentence. The decisions were not appealed, so that was the end of the case. 2 postscripts. Subsequently, he was charged with a sexual crime against a minor. and he was convicted by a jury, and he did do some jail time as a result. The other postscript is that there have been substantial changes to the child pornography legislation since that time. One particular one that I will point out is that for possession for the purpose of distribution or whatever, there are minimum times that must be imposed in sentencing. 1 year for an indictable offense and 90 days for summary conviction. For simple possession, 45 days imprisonment obligatory, and 14 on an indictable offense, 14 days on summary conviction. So, in a way, the outpouring that did occur certainly had a result in Parliament by the changes that took place. As far as I was concerned, I felt all along and still feel that I was a judge doing my job, and I did it as best I could, and no matter what was going on in the media. I think that finishes what I wish to say.
Thank you very much.